How do the parties initiate a mediation? That generally depends on how the parties arrived first to the decision to pursue mediation to resolve the legal dispute. If pursuing mediation is mandatory or required by court order or statute, it is very common in family law cases in many states where the court will require the parties to undergo some level of mediation through a social worker or through some third party to see if they can resolve the dispute amicably or between themselves without employing the services of the court to resolve the dispute. Now, so in a mandatory mediation, you're going to simply follow the court rules of the jurisdiction as to whatever is required. Now, if it's a voluntary mediation, and that means the parties voluntarily entered into agreement that required any dispute be mediated, or the parties after a dispute arises can simply say, hey, let's mediate this. And in that situation, the parties will agree on the procedure as to how it's done. But in any event, it's generally you submit your dispute to a third party mediator and you contract with them or hire them to help you work it out. Now, in most states, licensed or approved mediators will have to be licensed attorneys. And the reason is because in some way they're representing the legal issues of one party to the other, and they're helping the parties work this out. So there are certifications that some jurisdictions have and some licensing requirements for mediators in certain jurisdictions. But by and large, the parties will simply submit the matter to the mediator, and the mediator will generally have the level of expertise necessary to implement a formalized process or procedure for executing or carrying out the mediation.